Okay, so the product. What is it exactly that we sell to clients, that we advance to courts, etc.? It's not paper. It's not necessarily results. It is our judgment, our analysis, and our advice. That's what's up here. So that product, for a couple things about that product. First of all, it's obviously intangible. It's not something you can package and show to your client, but it can be invaluable to your client if you are the kind of attorney who gives great pre-thought to every case, provides good analysis, good judgment, rational thinking, and good options for the client. That lawyer is at the top of his or her profession. So when you're analyzing a case, to take the time beforehand, even if you're by yourself, and just think about the case, ask questions. You what if the case to death. You analyze it to 5 different levels. Many times your adversary is already stopped at level 1 and you've thought about it to level 5. You are way ahead of your adversary. Let me tell you something. Clients respect and pay for that kind of advice. I've talked about this in other videos. We have lawyers out there, they're kind of seat of the pants lawyers. They got the gift of gab, they can convince people of things a lot of the times, but they don't think through their cases, they don't produce a good product, and they just hope that what they produce will bring them fees. Number 2, the preparation of documents. You cannot believe the stuff that I see in my practice. Now, I see a lot of very smart documents, very smart analysis, very professional documents. But sometimes it's amazing what lawyers put out. Obviously, they sat down, they dictated it, they didn't look at it, get it out of here, I'm busy. If I have a lawyer, I'm dealing with a lawyer that I have never dealt with before, and I get something like that, right off the bat, I'm thinking, not a good lawyer, not very smart, not very professional. It sets up a dynamic within that case where I believe I have a lot of leverage. Now, I'm talking about not just faulty legal analysis. I'm talking about citations to case law that doesn't apply. I'm talking about typos. I'm talking about statements that make no sense. I'm talking about something that looks awful, right? And you would think, well, does it really matter how it looks? It really matters how it looks. One of the things that I did, and when I first started my practice, and I would recommend this to you, as you begin your practice and you get documents, some are terrible, some are mediocre, but some you look at them and you say, wow, this really looks good. This is obviously done by a pro. It's very impressive. I keep that. I then use that as a master for my documents. And eventually your library of templates for all kinds of things is extremely professional. One of the rules that we use in my office is nothing, and I mean nothing, goes out of the office unless it's near perfect. We look at drafts 2, 3, or 4 times, depending on what it is, of course. But we don't want anything going out of here with a typo in it, with misspelling, with something that looks sloppy. Certainly anything that does, cases that are cited that are not applicable, cases that are cited that have been reversed. I mean, that goes without saying, but it needs to look professional. The third thing I would talk about is when you're preparing your arguments and you have a case, and I mean, this is after you've met with a client, you know who your adversary is, you have a pretty good idea of what the arguments are. You need to sit down and over-prepare your case. We've talked about this in other videos, but I mean over-prepare. The facts, you've talked to every witness, you've looked at every document, you looked at the law, you looked at your law, you look at the contrary law. And especially when you're new to the practice, if you use that as a regular practice that you engage in, where you over-prepare, you're always going to give yourself an advantage over your adversary, even if that adversary is more experienced than you are. So it's a good thing to do for younger lawyers that are just coming into the profession. One of the things that I remember from law school, there's not much, but one of the things I remember, one of my law professors said to the class, if you can't explain it, you don't understand it. And I used that through my entire career. I'm going to sit down before I engage my adversary, certainly before I prepare my arguments to the court. Do I really understand every nook and cranny of this argument? And you have to just sit down and you have to spend time thinking about it, not writing, not talking to someone, thinking about it. If I say this, what will be the counter argument? If the counter argument is this, what is my response to that? If you've thought that through, again, as I said, maybe 4 or 5 levels, almost all the time, you're way ahead of your adversary. You have to ask yourself, do I really understand my argument? Does it make sense? Could I explain it to someone? If you can't sit down and within 3 or 4 sentences explain what your argument is, you're not done. You don't understand it. Also, the difference between creative arguments and frivolous arguments. Lawyers like to be creative, and there's nothing wrong with being creative. We like to make new law. We like to look at, bring different approaches to cases. Nothing wrong with that. But there's a difference between a creative argument and a frivolous argument. A frivolous argument has no chance of success. It has no chance of making any changes in the law, and it couldn't possibly succeed. If you practice in federal court, for example, and this is probably true in a lot of states as well, you are certifying when you send something to the court with your signature on it that you've done your due diligence, that the facts are true to the best of your ability, and that the law is right to the best of your ability. And in federal court, if you don't meet that burden, you can be sanctioned. But more importantly, if you don't meet that burden, your credibility takes a hit. If you become known as a lawyer who just throws out any kind of argument, however frivolous, to try to advance his or her case, your credibility is shot. You have to be in a position where most of the time, if not all of the time, your arguments have some basis in the law. If you sit down, and it's just not that hard, and you decide this is really pushing the limits, and sometimes it'll be the client, let's argue this, and you know darn well as a lawyer, that's really doesn't have any meritorious grounds in the law, don't do it. And the last thing I would talk about in terms of your product and your arguments is the losing argument. Look, sometimes you're going to lose. Sometimes the law is completely contrary to your position, completely not supported by your facts. Now, I'm not saying you walk into court and just, concede, but when you have an argument that you realize this argument under these particular facts, it's not an otherwise frivolous argument, it's an argument that could be made, but based on the facts of this case, there's no way you're going to lose this, or there's no way you're going to win this. Rather than advancing that losing argument, you have to find a way to finesse your way out of the case probably through negotiation. But when you have a patently losing argument, you know it, your adversary knows it, the court knows it. You're not kidding anybody. Sometimes the temptation is to fight on and never give up and never concede. That's a bad strategy. When you have a losing argument, don't advance it, find another way out.